Good morning, everyone. Law and Crime has their screen up like as if they're starting, so I thought I would start early. I don't know if they are just getting their camera set up early or if something's happening. So, good morning, GB. I see you. Hi, Michelle. Hi, Can Do. Hi, Bama Green Eyes. Hello, fellow Canadian Nikki. Nice to see everyone. Hello, Michigan. Is my audio okay? It's hard for me to tell. You guys let me know if the court audio is too loud or too quiet. Good morning, Cat Lady. Cat Lady's asking what I think about the overt act. I think my reaction yesterday told the story, right? Hello, Oklahoma. Hey, Emily from Florida. It's great to see everyone. So, I guess we're going to hear the rest of the motions today. I didn't check the docket this morning, but Owens is notorious for not filing things with the clerk of courts. So, we'll see what happens. Michelle says, can't believe she admits to hitting him. She said nobody touched anybody. Yeah. And you know what? Someone in the comments brought up a good point that I had forgotten about. Sarah told the detectives that she was waiting for Mr. Torres to come upstairs for intimate relations when he got out of the suitcase. Does that sound to you like she was terrified for her life? All of this is going to come out at trial, hopefully. Barnabas is saying you saw a jury selection. I did see some of that. It was amazing to me, some of the remarks of some of the jurors or potential jurors. Yikes. And I didn't realize that so many people don't watch the news at all. They just get their news from family and friends. That surprised me. Maybe I'm the one living under the rock. I don't know. Bama Green Eyes says Sarah needs cheat sheets to keep up with all her lies. You know what? I saw yesterday Sarah hand, I think it was Owens or Henderson. It was Henderson. A huge pile of sticky notes. Like, here are all my notes. Tons of them. Lisa says if she admitted to this now, couldn't she be charged with first degree? Well, she's claiming that it was self-defense. Hazel Eyes is saying news is depressing. Yeah. I guess you have to find the balance, right? A Squirrel says it's not like the olden days, so many news sources, which to watch. Yeah. I like to find several sources, and I purposely go look at things that I already know will have a different spin on it than the way I see it. It's just I like the mental exercise. Allie's saying, I've gone through many times in my life when I'm super into the news and other times when I barely follow the news. Sometimes it's all too much. Yeah, it can be hard when you're hearing horrible things and there's nothing you can do about it. Good morning, Yo M. Good morning, Nola stole the spoon. Ginger Snap says, because of Sarah's small wins yesterday, it's locked in her mind that she can win this case. So if the plea deal is still on the table, she won't take it for sure. Justice is coming. Hello, detective. Anne says, I'm a news lover. Interesting how on TV most news seem like talk shows. Yeah, and that wasn't always the way it was. I think with the advent of 24-hour TV, because we didn't always have that, right? And 24-hour news stations, I think they kind of had to just keep talking or delve into it a little more. AKA the cat lady says she saw two lawyers saying that the iteration of Sarah's story can absolutely be construed as first degree. Yeah, I think it can be construed as first degree. And I think the argument yesterday that Henderson made actually shows intent. She's saying she intended to leave him in the suitcase until who knows when. There was no indication of when she intended to open the suitcase, right? That is intent. Smacking his fingers is intent. Zipping him up in the first place and saying, I'm going to make him squirm is intent. And I don't know about you guys, but I do not believe for 1 minute there was any hide and seek at all. I don't believe that suitcase was downstairs to begin with. I think it was upstairs. I think she did something to him that incapacitated him. I think she thought that he was unalived. So she had to do something with him because whatever happened to him was her fault. If he had fainted or something from some other cause, she wouldn't feel the need to hide him. And the fact that his paperwork was also in the suitcase, along with his medication, it could be construed as her wanting to get rid of evidence. And Brian, when she called Brian that night, he either couldn't make sense of what she was saying or told her to flock off, or I don't know. But when she called him, she didn't get any help. And so what? She spent the night working it out? She went to sleep? Figuring, sleep on it? I don't know. Somebody's pointing out that Henderson pointed out that if she goes on the stand, she gets cross-examined. I eventually yesterday came to the thought that perhaps much of what Henderson was doing was actually for Sarah's benefit rather than the judge's. Ellie's laughing at my flock off. Yeah, it's old. Ginger Snap says, I've said since the beginning this is a first degree case, but also understand why the DA chose not to overshoot. Yeah, I agree. I personally think, just based on the evidence that we know about, I personally think that this was first degree, but it would be really tough to prove. Hi, Diana. No, you're not really late. GSD, Dog Mom. Hey, GSDs, love them. Is asking if there's a time of death yet. The autopsy says that there was skin slippage. So that tells me that he'd been gone, between 10 and 12 hours at least. At least. But I am not a pathologist, so, I could be wrong. If there are doctors out there who know about this, maybe you can chime in. John, another day with Looney Tunes Boone. How many sets of papers will she shuffle today? Yeah. I think it's hard to be in the spotlight. She knows she is. So I wonder if she's trying to keep busy or stop herself from fidgeting in other ways. I think it's like a self-soothing kind of thing too. Lisa says this is an awful death. No one deserves that. Yeah. Pamela is saying, good morning all. Lori, write that book. My publisher, I owe my publisher 2 books. I owe them 2 fictions that I promised them. And I had planned on writing one of them this summer. So I was supposed to have it in, and I don't have it. I've been on YouTube making videos. KPM saying a couple of lawyers opined the state could up the charges to first, and maybe the judge will give her life. Yeah, I think this trial is going to be very interesting, because I really believe there is an awful lot that she was hiding, as much as she babbled on. I don't know if we'll ever really know. I'm hoping that the evidence will give us some clues. And I think a lot of people got onto this hide and seek and tried to incorporate the hide and seek into theories of what may have happened. And I find that interesting, because that assumes that there was hide and seek at all. I don't think there was. Marcia is saying someone theorized that George's brother may have beaten him up because he was cheating on his wife with Sarah. No, that's not the story at all. Hi, Castro Valley. Somebody saying that by switching up the story the way Sarah has, it really changes the case. Yeah. This is an example of why when the police get you into an interrogation and you talk, especially if you talk a lot, they like it. You can talk about anything you want. Just talk. Because they get you pinned down. Sometimes you'll see an investigator seem like they're believing the person when the person's obviously lying. What they're doing is they're getting that person pinned down to that lie, so that when it comes to court, when all the evidence comes in, well, they're locked into this lie, and now they have to wriggle out of that. The detective says, yeah, she's still monsterizing his family. It's disgusting. Yeah, but that's the way they operate. I can't even count. I think, okay, if the accused didn't blame the victim in some fashion or vilify the victim in such fashion, that would be rare. You're asking about fluids left in the suitcase. The reports didn't indicate that, But that doesn't mean that wasn't found. We're going to have to wait and see. Ginger Snap says the defense orated poorly yesterday. Did they just start looking at discovery the night before? I don't know. I don't know. I think some of this show was actually for Sarah's benefit. I think Sarah has been demanding, this is just my theory, okay? So this is not a fact. It's just what I'm thinking. That I think that Sarah has been demanding that her lawyers all along argue certain things or respond in a certain way or say certain things or demand certain things that are illogical, unreasonable, and that sort of thing. And they won't do it. And I think here maybe Owens and Henderson, for that matter, are kind of going along with it to prove to her it's not going to work. Perhaps. I don't know. Jay Roberts says, yes, if you're playing hide and seek, why is your medication and your paperwork in the suitcase? Exactly. KPM says, I can't believe that they are using him attempting to save his own life as the overt act. It's stunning. Yes, it's ludicrous. Mr. Zane is asking, when will opening statements be? This is taking forever. Well, opening statements, I'm guessing they're actually going to be Friday. But, you never know. And as for jury selection taking time, I'm glad. I'm glad they're asking questions. I'm glad they're really going through it and making sure they're covering everything, because we don't want a mistrial. We don't want jury shenanigans or problems, right? There's enough crazy drama in this. Jay-Z says, I think her smirks are for her former attorneys because Owens and Henderson are doing exactly what she wanted argued. Yeah, maybe. Aaron Ireland is convinced that the incident with Sarah's son in the suitcase had something to do with how Mr. Torres ended up in the suitcase. My understanding is that, even from Brian, said that was just like fun and games. He was only in there for a second. So I don't know. I don't know. Thank you, BJM. Watson says hello back. Good morning, Michelle. CB says, I hope the jury hates her. I hope the jury sees with clarity what the facts are. That's my hope for the jury. I don't care whether they hate her or not. I hope they see what the truth is. Nicole is suggesting that maybe Mr. Torres' things were in the suitcase because he was moving out and she didn't want that. And that's a plausible theory. I would wonder why, though, he would use her suitcase, right? And why all his clothes and other things weren't in the suitcase if he required that big of a thing to carry his belongings out. Oh, somebody's suggesting, Mark is suggesting that if the overt act of George sticking his hand or fingers out of the suitcase happened before or after the video that Sarah made, that would make a difference. Yeah, it would. But either way, she was sitting there taunting him. Cat Lady says, I just keep telling myself that all they need to do is show the video, the suitcase video. Yeah. I mean, to me, that suitcase video shows revenge. And even her own statement saying, well, once he was in the suitcase, I was thinking about times before when he hurt me and I got mad. That's not scared. That's angry. That makes it revenge. That makes it depraved heart, right? Hannah is saying all she wants is a total submission from everyone in her life. Yeah, regardless of how reasonable. Yeah. And you see that pattern of behavior all the way through, right? The way she speaks to her lawyers, the way she speaks to the judge or the judges. At one point, she even accused one of the judge of taking a cut, like basically making money or taking bribes and being corrupt. Jay-Z points out that Sarah said, I wanted him to squirm or whatever. Yeah. GSD's dog mom says revenge and lots of malice. Yep. And KPM said, yes, she said he had cried wolf before. So she didn't believe him. And that raises another question. If he cried wolf before, what does that suggest? That suggests there was a previous incident in which he was claiming he needed help, where she was doing something to him. Doesn't that suggest that to you? Diana says she's a control freak. Yeah. Lisa's saying state can upgrade it to first degree now that she says it was intentional. I don't know if they will, though. Vet says, I lived with a man that's exactly like her for 13 years. There's a lot of truths to what she's saying, but most of it is word games. Yes, she does play with words. Amy, 55. She called the police so many other times. Why not then? Or walk out the door. I can actually come up with an argument for that on the defense side, but I think I'm not going to. As far as walking out the door, yeah. She claims to the police on another occasion that she ran off barefoot and ran to Brian's barefoot. So, you know. Zen Scout says we never get to see the jurors' faces. Yeah. But the jury will see. Good morning, Illinois. What are we going to see today? Buffy is asking. We're going to see motions arguments. So it's supposed to... I started early because Law and Crime had their cameras up. It's supposed to start at 9. Jury selection is not supposed to recommence until 10. So from 9 to 10, I'm expecting we're going to hear arguments. Oh, somebody in the courtroom, I'm hearing from the chat here, somebody in the courtroom said Chelsea's the lead detective on the case, came to court and the defense table was unhappy. I could see that because usually you ask for an exclusion of witnesses. Often, though, the lead investigator is exempt from that. So, we'll see how it goes. Rachel says, I hope the prosecution will thoroughly pick apart the narrative she will have to give in her testimony. Oh, I expect they will. Jay-Z's asking, do you think the jury will be set today? Probably by the end of the day. But, I mean, who knows, right? Frauke's saying, no provings first degree for what? She can get life for the charge as it is already. Why should they bother to make it even harder on everyone? Yeah, I think they won't bother. AKA the cat lady says, usually there's one case agent that remains throughout. And here, usually it's the lead detective. Sidonia says cross-examination of Sarah is going to be wild. Should we guess how many objections? I think you're saying, Amy, Owens will have first day of trial. I don't know. And, it's not the number of objections that matters. It's the quality of them. Michelle's saying, I hate that opening statements will probably be on Friday, giving the jury a weekend break. Why do you not like that, Michelle? I think I'm missing something there. Amy says Owens seemed to object, then lead her to a reply when she was on the stand. Yeah, he got away. You're not supposed to lead your own witness. If you are on the opposing side, you're allowed to lead, to ask leading questions. But you're not supposed to lead your own witness. And he got away with that. So I hope that is not the case during the trial. Hi, Dr. Barry. Dr. Barry has to work today. Good morning. Nico is saying, are jury questions allowed? I don't know. And I remember the first time I heard a jury asking questions, I was surprised because we don't do that here. So that is something that is different in the United States. I hope you're not hearing Watson. She's sitting behind me licking her paws. John, do you think the detective could have handled the interrogation better? Personally, yeah. However, it's easy to sit back and judge when you're not in that situation. And what we didn't know at the time that we all watched that interrogation, but the detectives knew, was all the other background information that they had. So they may not have felt that they needed to really try and get a confession, or if they just wanted to elicit something from her, and she gave it to them. She gave them the lies, and she pinned herself down on those lies, and now it's going to come back and bite her. Oh, Vet is saying jury questions are not allowed in Florida. Thank you. I did not know that. Are we on? Rachel is saying, I thought jury questions are allowed in Florida. I don't know, you guys. I wonder if Google will know. AKA the cat lady says, I think they played Sarah perfectly by not kissing her butt. I think there can be arguments both ways on that. I know that Chelsea was sick during that and pregnant. So that makes a difference. I think I might have kissed Sarah's butt just to get her to talk more. But that's just me. Somebody else might have thought, hey, let's be confrontational. Pamela says, I can't wait till Mr. J gets a hold of her. Yeah. See you later, Missy Brewer. We'll see you in the comments later. Oh, KPM. Hang on. Okay, KPM, you cited a Florida rule. And am I correct that it said jurors can ask questions in writing? I think that's what you said. Michelle is saying, I think being confrontational brought out the real Sarah. I found it interesting that how hard Sarah fought back. And that also shows that the statement was not involuntary. Oh, thanks, KPM. Jurors be permitted to submit written questions directed to witnesses or the court. Oh, okay. So KPM has found the rule, thank you, that says jurors can ask questions, but they will be in writing. Caitlin, I don't know how the defense got Mr. Torres's medical records. Don't know. Hey, KZMZ Fox, another Canadian fan in Cozumel, Mexico. Hey, I've been there. Nice place. Janny saying, my favorite yesterday was Attorney Henderson saying, so there. I did hear that. And I took it as, I didn't take it as, so there. I took it as, so there, like there, okay, there's that. So that's there kind of thing. But I could totally see how it could be taken a different way. And maybe my interpretation is incorrect. Cat Lady says, Sarah fighting back in the interrogation, I think you're saying, also demonstrated that she's not a victim here. She reads as super controlling and abusive. Yes, she had to control. I mean, she even controlled whether he was doing crafts or what music that they listened to. And she was in contact with his probation officer. Now, it's not unusual in DV cases for a probation officer to contact the victim to make sure that everything's going okay. But, I mean, we don't know the backstory there, but it struck me as very controlling. So, yeah. And the other thing during the interrogation, she didn't weep. I think a lot of you, and myself included, look at this and think, I would be mortified if I unalived anybody. It's like, even if it was an accident, even in self-defense, it would be horrible. But we're not seeing horror and grief and shame, none of that. Hey, Mel. The Cat Lady said, George didn't have a phone, so the probation officer had to go through Sarah. He did have a phone at one point. The other thing that was interesting to me is that in the suitcase, they found a phone. And it was not Sarah's phone. So it makes me wonder if he went and got if that was his phone and maybe he got a phone behind her back. I don't know. I don't know who that phone belonged to, so that's going to be interesting. Did the judge rule on the snacks? I think it was more like, I'm not sure. I think they just said, look, she's getting, we'll see if the jail can do anything about it. Good morning, Carolina. Zen's Scout says all of Sarah's controlling. She can't control her facial muscles. Yeah, she's not really polished. Let's put it that way. Colette, I'm not really sure why, but not allowing someone to listen to the music is cruel, I think you said. Jay-Z, unfortunately, since he was a pretzel inside the suitcase, the phone was useless. Hiya, what a time. Thanks for being here. Michelle's saying, I wish they'd start already. Got to get ready for work. Yeah, court never starts on time. Good morning, Leslie from the UK. Detective, she definitely has resting bee face. A lot of us do. I do. People have asked me what's wrong, and there's nothing wrong. Frauke, I would think that even people like me with hardly any emotions at all would be more devastated than Sarah. Yeah, it's stunning. Hello, Ireland. Are we on? There she is. Oh, all smiles again. Is that the same suit but a different top? Jay-Z, I have a RBF. Yeah, me too. And sometimes I look angry when all I'm doing is thinking. This is probably as good as Sarah has ever looked in her life. Or at least since she started hitting the bottle. Buffy, there will not be opening statements this afternoon. They are still selecting the jury. This afternoon, the defense will get to ask questions of the jury. And after that, then they can make arguments for cause or strikes for cause. So Ray B's asking if the second attorney sounded inebriated. I didn't think that, but I know a lot of people commented that. There are lots of reasons why people might sound like that. If they've had a stroke in the past, Bell's palsy, all kinds of legitimate reasons why somebody would sound like that. I can sound like that when I'm tired. So I don't think so. Rita's asking, why is there a cell phone on the table between her and Owens? Don't know. Much Endeavors is saying, yeah, partial stroke could do that. Cassie asked, do you think the second attorney was playing dumb? I don't think they're actually dumb. Sometimes, an attorney will ask, this is true for police officers too. Attorney will ask a question that might seem stupid. But when you're in court and you're on the record, and whether or not you object or do something one way or another can really make a big difference, you want to be clear that you understand. So it's better to clarify.
William Shea for the state.
I can hardly hear them. I think I'm going to try and turn them up, okay?
Ma'am, good morning. Can you state your full name and date of birth for the record for me? All right, Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the clerk's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating you to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing, because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment. You did not. Okay. Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we
Makes it very difficult to prepare for opening statements when I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Can we finish jury selection? Mr. Henderson is going to take a minute. This afternoon, I guess we start at 10:30 or 11, and that's going to spill into probably late afternoon before we actually get a jury pick. Can we just agree on Friday morning starting opening statements? That gives her time, him time, me time.
State?
We have an out-of-state witness and people that are scheduled to come in, so we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half, 2 tops.
Okay. Correct.
I believe we each have 10 strikes.
That's correct.
And that's going to take.
Okay. Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay, all right. Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Sure. Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor. Thank you.
State or Mr. Owens?
30 minutes? Excuse me? No, not that long. Okay.
How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? No objection. All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
There was a lot there I couldn't hear. I think it's good that Mr. J wants the actual order. Yesterday, when the judge ruled on the battered spouse defense being partially allowed and, the state's motion partially granted and partially denied, I had questions in my mind about specifics going forward and what really would and wouldn't be allowed. And there's lots of wriggle room for the defense to do things that, in my opinion, they shouldn't be allowed to do until she testifies. And the judge didn't spell that out. So I'm glad that Mr. J is asking for the actual order and wants to discuss that and wants that clarified. Because everybody does have to be on the same page. Because if the prosecution thinks it means one thing and the defense thinks it means something else, then in the middle of trial, when somebody objects and says, well, we talked about this, you don't want an argument then about what the judge meant or what was allowed and not allowed. So I do think they need to go over it. So I'm glad that they're doing it now, and understanding that and making sure that that's clear is going to allow both sides, really, but Mr. J to formulate questions better. And this is very late in the game to be having to rework things that he wants to use for a voir dire and rework potential opening statements. This is very late in the game for that. So, I mean, these guys are working their butts off. When you see court take a break, people sometimes think, oh, they take so many breaks that, it must be an easy work day. It's not. A lot of times they are working through breaks. They're working through lunch. They're working at night. So I'm going to check the chat here. Oh, was Sarah touching the lawyer's paperwork? Yeah. Jenny B says, glad state is rushing things up. They were ready to wait till Monday for openings. Really? Oh, you mean the defense were ready to wait for Monday? Unhyphenated said, didn't the judge say that the term battered spouse syndrome couldn't be used? No, it could be used in opening, but they couldn't put up an expert witness without first laying the proper foundation, which means Sarah would have to testify very early in the trial, or at least before they put up any experts. Rachel says, I cannot believe she is grabbing Owen's paperwork. Hands off, lady. Yeah, I believe it. Control freak. Remember one of her earlier letters? She was saying that how the lawyers are disorganized, and if they would only let her handle it, they could see how good it could really be. Frauke says, so no job for me. I can get grumpy when I can't eat for more than 2 hours. Yeah, a lot of people get hangry. Sean says, I heard yesterday Sarah spilled a glass of water all over Owen's paperwork. I didn't see that. Lisa saying, did you see that the ACLU has gotten involved in Karen Reed's case? Yeah, I saw that. You know who has, I think, Melanie Little. She is a YouTuber. I think she covered that, and she usually does a good job with that. Elle is saying, I imagine spending any significant time with Sarah will aid you a lot. Yeah. Mad Mystic Tarot says, why didn't she put those organizational skills towards an actual job? Well, maybe because she couldn't be the boss. Maybe because she would have to play well with others. Maybe because she couldn't do and have what she wants when she wants. And that actually brings me back to the issue of the snacks. Owens said that she's getting very tired, very fatigued, and that Sarah thinks that having the snacks will help her get through the day because she's tired. And I thought, she's probably tired because she's not accustomed to having to work for 8 hours or even sit and attend to something for that length of time and behave herself for that length of time. Who here, when you got your first full-time job, found that you were really tired the first week? Anybody? I'm going to switch screens for a minute so I can. The screen I'm looking at doesn't allow me to see the chat as well. Okay. Dr. Barry, I think she also has an issue with alcohol, and that likely impacted her ability to hold down employment. Yes, that's true. Yes. I think, okay, so Christine, we're talking about, were you tired the first time you got a full-time job? Christine says yes, and legs hurt because I stood all day. People are saying it was too long ago to remember. Fernanda says Sarah is undisciplined. Yeah. Joy says not at a first job, but any new job, stress will add to tiredness. Yeah, stress itself will do that. Also, an unfamiliar circumstance. Frauke says working as a vet assistant tired me way less than vet school. Having that bit of brains, I got to rotate. Like, that was wild. Yeah, the mental energy it takes. Because sometimes a job sitting at a desk where you have to analyze and think a lot really does fatigue you. Your brain uses a lot of calories. Jessica says, first week, I work with Amazon customers and I can still get exhausted in 8 hours. Haha. Yeah. Yeah, Vicky's saying that she was exhausted too. Yeah. So Sarah, I don't know if I'm going to switch back yet. Hang on. Sarah has not had to sit and attend and expend that energy and stay still and be on for that many hours. She's just not used to it. So I think that's got to contribute to her being tired. Jay-Z says, I do remember the hiring manager didn't think I was going to last long. I outlasted him and am still with the company. Good for you. The detective says, I have no sympathy for her. No, neither do I. Buffy says, many workplaces have some version of Sarah to tolerate. Yeah, it's unfortunate, isn't it? Mad Mystic says, I work 12-hour shifts and barely have time to break for my full lunch hour. Yeah. Sarah probably has no idea what that's like. The jury doesn't get snacks. Why should she? Yeah, I remember going from working 8-hour shifts and then having to work 12-hour shifts. I was tired, man. The 12 hours and then add to it, you're driving back and forth. You barely have time to do anything else. Jenny B says other inmates waiting with Sarah downstairs all get the same. Yeah, she's special. Diana says that Sarah's mask is going to slip, guaranteed. Yeah, I don't think she can keep it on for this long. CJ says court is exhausting as a juror too. Yeah, that's true. So much waiting, up at 5 or earlier, not home until 6:37 with traffic, neck and legs hurt from the city pavement and turning to the witness box. Sounds like you've had some experience there. Yeah. And when you take a juror and put them in that situation with that level of responsibility and they're unfamiliar with the language, the legal language, it is a challenge. It is a big responsibility, and it's got to be tiring. Amanda says, well, here, it's not fair. It's not fair. We'll hear. I see. I see what you're saying. Let me switch back. There's still nothing going on here. Diana says it's hard for angry people to act normal for long periods. Yeah, I think so. Have you ever met somebody who isn't saying or doing anything bad, but their anger just sort of oozes out of their pores? You just know they're an angry person. Have you ever come across somebody like that? Venus is pointing out, as viewers, we can tune out. The jurors have to suffer through every minute. Yeah, that's right. Planet Bongo San says, has anyone ever pointed out to you that you could do a wicked, accurate impersonation of Bart Simpson if you wanted to, man? Really? Nobody's ever said that to me before. That would be funny. Next time I'm with friends and have had a couple of glasses of wine, I might try it if I remember. Amy says Sarah will never survive Cross. Cat Lady says, yes, I was terrified of one boss I had. Yeah, there are people who are you just know, right? Nola, or someone who can turn on a dime. Yeah, from sunshine to storm without reason or warning. Yes. Yes, and I could see that in Sarah as well. I'll be real nice to you, but when I figure out you're not giving me what I want, look out. Leslie, shame we can't see the jurors' reactions when they watch the suitcase video for the first time. I expect there will be YouTubers and reporters in the courtroom who can comment on that and at least give us an indication. Monique says Mr. J was very good yesterday. Light and explained things really well. Am's in Michigan. Gonna have popcorn ready for Cross. Yep. Al's saying that Sarah was caught with quite a few things in jail that lead her to believe, who knows? Frauke says, I once had a boss that tried to put me down, but I got out of him quickly. Jenny, no, Sarah is not diabetic. Owens said that yesterday, that there's no diagnosis or anything like that. Monique is asking me if I watched jury selection yesterday. Yes, I did. Leslie is saying Henderson seems to like the sound of his own voice. Yeah. I don't know. I didn't get that, but everybody can have their opinion. Mad Mystic, I wish I knew how Mr. Torres survived being in the same space with her day in and day out. Did the Karen behavior not bother him? I just don't get it. Well, I mean, that is a good conversation, a long conversation probably that could go on and on. Whether it's psychological abuse, whether it involves physical, and we know that it did. We know that both were happening to Mr. Torres, and it appears that maybe he was given it back a little bit. Anyway, in those situations, it's not as easy as people think to just walk away. There's so many reasons why. One of the reasons is you doubt yourself, you doubt your perception, you make excuses, you try to be understanding, you feel guilty, you think, well, maybe if I just try harder. There are so many, they gaslight you. There are so many reasons why people don't simply walk away. And that's just at the beginning. And once you're trapped, once you're psychologically trapped, it's a whole different thing. Watson just turned on the vacuum robot thingy and then took off. Diana saying Sarah made sure that she isolated him. Yeah. And that's one of the things that abusers do. That's really common. The other thing that happens is when friends and family sorry, I'm going to turn this off. Okay. When friends and family see or realize what's going on, they get frustrated with the victim. And they say things like, well, what's wrong with you? Why don't you just leave? They get tired of hearing it. And so victims stop talking sometimes. Oh, Dr. Barry, hang on. I want to see this comment here. Ooh. So, Dr. Barry says male victims of DV can have shame about not being man enough. Yep. He was also a physically small man and may have felt reporting her would make him look weak. And that's a big yes. And I've heard that a lot with male victims. They make excuses, they're embarrassed, and even other men will laugh at them. Oh, what? A girl beat you up? Are you kidding me? So they do face that stigma. It makes it. There are additional reasons that make it hard for a man to report. Frauke's pointing out the cops never helped Mr. Torres either. Yeah. Yep, here we go. Dr. Barry saying sometimes even the police will laugh. Yeah. We'd get in trouble here if we did that. The police in this case seemed to want him to press charges when he had marks, and he didn't say anything. He wouldn't he wouldn't report on her, which is typical of abuse victims. Oh, remind me if I forget to talk about the plate glass window issue and the assumptions that are being made and repeated as fact. I want to address that. Dr. Barry says there was one incident where she was arrested, and I think the prosecution is going to bring it up. Yes, that was the one where he was charged, and what happened was he was defending himself because she was strangling him, and she was charged with the strangulation, and somehow that got dropped. So
we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. We get appearances for the state. Okay, Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much. Oh, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday, and my understanding is both the state and the defense were provided copies of same. Mr. Jay, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate?
Yes.
Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure. Madam Clerk's providing you a printed copy, sir. Bless you. Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
Owens has it in front of her so she can see it. I don't know that she's entirely reading it. Oh, how to move the captions up a bit. I don't know how. Let me see. Wonder if I can change this. Nope. Nope, that doesn't help. I don't know how. You know what? I'm gonna make note of that. Learn how to move captions.
Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But page paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida 4th DCA, 1971, Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111, Florida 5th DCA 2017, Rudin versus State, 182 Southern 3rd, 724 at page 726, Florida 1st DCA 2015. So what we were asking for is, in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid, was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you.
That's exactly what I was worried about yesterday. And that's exactly what needs to be made clear. And I am glad that he has included so much case.
Response.
I just have one question as to what time. Are we talking about for Dyer? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then the motion's granted. So the court's going to rule.
Yes! Yes! So this means that during trial, the defense cannot be dragging in Mr. Torres's reputation, prior bad acts. This was critical. And Henderson said, I agree, because Henderson knows that is the law. And Henderson actually argued that himself previously. This is how it's supposed to go. So they cannot bring up any bad history of Mr. Torres's unless and until the affirmative defense of self-defense or battered spouse syndrome has been made and that information and foundation has been laid, which means Sarah has to testify early, maybe right away. Otherwise, the defense has nothing to present. Beautiful. Love the way that Mr. J did this. I'm really glad that he made sure that was clarified.
Rely on that specific excerpt in Holland, 916 7 2nd 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense and bracket internal citations omitted. That's the standard. So, hearing no objection from the defense, the motion will be granted.
Judge, just understand, clear on the record, it's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a crime of self-defense. That has to come from someone, and in this case, we all know that has to come from yourself.
Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6 DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has submitted apply to trial and the organization or the flow of the evidence.
I can't hear a flippin' thing, can you?
Certain witnesses can testify. It has nothing to do with or die nor opening statement.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
Lisa, you're asking why the defense can bring up battered spouse defense and opening statements. Opening statements is a roadmap, right? It's an anchor. It's a roadmap to how the case is going to unfold. Opening statements are not evidence. And yesterday, during the discussion, the prosecution sort of sent a shot across the bow saying, hey, all right, go ahead and use that in your opening statement. But if you end up not being able to prove that, we can point to the fact that you used that in your opening statement and you didn't prove it, and the burden of proof doesn't shift there. So that's why I hope that explains things.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today.
Ooh. So, did everybody catch that? The prosecution wants to make sure that Mr. Torres sticking his fingers or his hand out of the suitcase does not constitute an overt act. The prosecution wants to make sure that's clear, it's on the record, it's in writing, because they don't want the defense to try and use that as a way to wiggle in battered spouse and, prior bad acts, even if it's going to fall flat. So I think this is good. But the judge is like, yeah, we're not rehashing all that. It speaks for itself. So I think it's good that Mr. J got that on the record, because when the defense tries to pull that, or if they do, then the prosecution can get up and object and say, but Your Honor, we talked about it twice.
Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. You know, I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the 5th amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by...
I'm not talking about 2. You don't object to 2. Talk about 3?
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Miss Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Wow. The defense team strikes again by dumping stuff onto the prosecution. So this prosecutor had to go through all of these, not like one PDF, go through all of these pictures, and some are sideways and upside down. Like, the jury is being selected. It's not like Mr. J has nothing to do. This is on top of everything else that's gotten thrown into his lap. I hope that he's actually like Superman or something and has no need for sleep, because he's going to need it. This is crazy. And the pictures sent to the prosecution by the defense at this late hour don't even match up with the records, the health records that they say they match up with. So they're going to have do a whole thing on this now. Wow.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2, when the defense said discovery exhibit.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs, evidencing something else, was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that.
The 81 pages are not at issue.
I understand, that they were given Sarah Boone from the Advent Hill report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last night that we had not sent them. So we provided those to the state as soon as we were aware that we had not given them.
Okay, is my mic sound better and less loud now? Can you hear me okay? Owens is now playing the same game as he always plays, right? It's, oh, gee, well, we just realized it yesterday and we were unaware of that they didn't have it, so we sent it. Doing the best I can, Judge. So who are you saying, Mad Mystic, to speak into the mic? Because first I'm hearing I was too loud. Or are you talking about Owens? I don't know. I can't fix the sound. I'm sorry. So now they have to talk about this, and Owens is playing dumb. It's frustrating.
And what do the 119 pages evidence?
Their medical records from the hospital related to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony, whether or not it was cooperative. Her testimony that she suffered an injury at the hands of George Torres.
Okay. I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
Oh boy. Oh boy. Mr. J has forced it so that Owens is finally called out for the game playing of not providing information that he's supposed to provide. And he plays the game of, oh, gee, well, as soon as I realized, oh, gosh, I didn't realize. Oh, goodness, I didn't know. I'm sorry. I came on the case late. Gee, all the excuses. Now he actually has to be accountable on the record to the judge. Wow. It's frustrating, though, because I cannot hear what Owens is saying. Veronica, we are getting on with it. This is pretty important.
Judge, my understanding is the first 81 pages were medical records of Sarah Boone that we'd gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week? Okay. I'm going to continue with the balance.
So Owens received the records last week. So the question becomes, why then, if he's supposed to turn those over, why then is the prosecution getting them this morning? And I like how the judge is saying, oh yeah, what day last week? Be specific.
Balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. Well, I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the BAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
Owens knows he's supposed to give it to them, and he's standing up like, and what he said, I don't know if you heard, but he said, do you want the exact pages? No, I want some other page that has nothing to do with it. Come on.
Appreciate it.
Got staff, you're in the
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize, you're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to the various medical facilities asking for records, and we're just waiting on a response.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Warner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
What specifically is relevant? What page? What date? What document? You're not answering my question, counselor.
I didn't say we were going to introduce these records.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits, this exhibiting evidence. I intend on potentially the doctors, the experts, Dr. Warner, Dr. Harper, to rely on these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records. They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course experts can rely on inadmissible evidence if within the course of that area of expertise it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
All right. So Owens is saying it's really hard to hear. So if I've missed something and you heard it, let me know. But Owens is saying all this stuff that we dumped on the state at the last minute. We're actually, it's on our exhibit list, but we're actually not going to introduce any of it. But the doctor may rely on it. And so the prosecution is saying, well, okay, if the doctor's going to rely on it, when are we going to depose the doctor then? Because the doctor hasn't seen these, it seems, but it's hard to tell. And Owens just got up and admitted, no, the doctor hasn't seen these. So why do you have it on an exhibit list at all? This is wild.
I don't want to get in a situation where we're going to take another deposition. So I'll wait. I will not ask her to review these.
Okay. State with,
That was the only purpose.
okay.
And you know what else I notice here? Look on the desk in front of Owens, between Owens and Boone. That mic is facing away from the people sitting there. Who changed that mic so it's facing away? Was it one of the defense attorneys? Was that intentional?
So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay, all right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail call.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania, and Massachusetts. We're not referring to those. We're only referring to the ones involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because you can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah Boone's testimony about her injuries, photographs, the officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records.
Okay, I'm not sure. So I've turned down my mic a bit. I hope that helps. Somebody was complaining about that. Is it better? Anyway, so I'm not sure if how much everybody was able to hear, but basically the defense wants to introduce Mr. Torres's criminal history, but they don't have a criminal record, so they're looking for things that other government agencies have that would prove that. But none of that matters. What matters is what Sarah was aware of. So the defense is basically trying to throw mud in any way they can get away with. And the prosecution is saying, just because somebody else said something doesn't mean Sarah knew about this. So therefore, it wouldn't go to her state of mind. That's the gist of it.
hundreds of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits, and that's what our objection would be to believing that what that was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Brennan will testify, I've seen Dr. Humble will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered that she has nowhere to turn. His family can't help her, she has in the group. The state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. At her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases, so she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what the
Okay, not sure how much you're hearing, so I'm going to tell you the gist of what he's trying to argue here. So, in the past, when Mr. Torres had been charged in relation to Sarah, the state ended up not proceeding. So, in one of those situations, Sarah had gone to the prosecutors and said, I don't want this prosecution to continue. In the rest of those instances, there is no record of Sarah having done that. So just sort of stick a pin in that. What Owens is suggesting is that, well, the victim, he's calling the victim Sarah now, went and wanted the charges against Mr. Torres dropped, and that shows that this is part of battered spouse syndrome. And that is true for the victim to help an accused batterer get out of jail, get out of trouble, get a reduced sentence, all of that. It is common for victims to do that. But that doesn't mean that was the case in this case. There's record of only 1, not many. There's also allegedly a video on Sarah's phone of her coaching Mr. Torres on how to get the charges dropped against her. And there are other reasons why a prosecution doesn't go forward that have nothing to do with whether or not the victim says that he or she want the charges dropped. And one of the big reasons that cases don't go forward, that they drop a prosecution, one of the huge reasons is no reasonable prospect of conviction. So if the state's got a case that it's really bad, they can't in good conscience put a citizen through that when it's not going to go anywhere because there is not actually evidence. And in my mind, that goes more toward Sarah potentially being a false accuser. So this is what's going on here.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history?
Owens might want to introduce something tangible. But you know what? If he introduces that, then what? Then you need to call that attorney to the stand and have them explain, because you can't just sort of extrapolate and make suppositions. It's easy for me to sit here and say, well, I think this is probably the reason, but you can't do that in court.
Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I'll withdraw the prior criminal history.
Okay, all right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color-coded this and I miscolor-coded this one.
Didn't introduce anything on 20.
Okay. Then, based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay. I'm going to overrule the objection as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, we anticipate is going to testify for the state, may testify for the defense, and he may be considered an adverse witness or a hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect, for impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of her being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that divorce with their.
What does
And on what he says,
what does the non-payment of alimony have to do with what's happening in a family case?
well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid alimony for, he's supposed to pay $1,000 a month for a number of years, that he's just failed.
All right. I've turned my mic down again. Is it better now? What they're talking about is Brian Boone. And the state wants information about their family court and alimony. They don't think it's relevant, right? And what Owens is basically arguing is that because Sarah and Brian are arguing over alimony, it makes Brian biased against Sarah, according to Owens. Isn't that something?
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation.
Wow. If you were on the jury, and you hear the defense asking about why aren't you paying alimony? I mean, what do you think? What do you think in this situation? And the other thing is, the defense goes to lengths to prevent the jury from knowing that the defendant is in custody. Well, if they ask Brian Boone on the stand, why aren't you paying alimony? He's going to say, well, because she's in jail. Why aren't you paying child support? Well, because I have the child because she's in jail. So Owens is inviting error. He's inviting a problem here. Wow. The nerve.
And I don't know because that's not my case. I haven't looked at it.
That's been decided. He hasn't been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
So once again, Owens is gonna, I'll look at it and I'll let you know. Jury selection is happening. How long has everybody got to wait? KPM is saying he's also not being told the truth by Sarah and will get burned. Yeah, I think he has a steel butt, but yeah, Sarah's going to burn herself. CB says Sarah should never have access to that child. I agree. Michigan says Sarah wrote letters to the previous judge about not getting alimony. Yes, she complained. I think she wrote the letter that she wrote, that I think you're referring to, is she actually wrote to the family court judge and claimed that Brian was abusing her while she's in custody. So is that her definition of abuse? For her, being given a boundary is somehow abuse. So, if Owens wants to bring all that in, well, maybe that letter can come in too. And maybe the argument can be made that, well, she thinks everything's abusive. That doesn't go her way. I mean, really, if they want to really get into slinging mud, there is much mud to be thrown around. Kathy says, I think the honeymoon is already over with Sarah and Owens. He knows he has to tough it out a couple of weeks and he's good. Frauke, abuse equals doing anything she doesn't like, pretty much. Hello, Belgium. Unhyphenated says Sarah will take down anyone in her way. Yep. Jessica says Sarah tapped him and he ignored her. I didn't catch that. Buttercup says, then just don't call Brian as a defense witness. Yeah, if you think he's biased. What a time to be alive says, can this guy not use the microphone? I suspect, I can't prove it, but I suspect he's doing that on purpose. Cat Lady says, Brian has been putting the alimony into a separate account instead of Sarah until it's decided. So it sounds like it's being held in escrow until there's a final decision on everything, right? Benton, ignore the audio trolls, please. Thanks. Sometimes I can't tell if it's trolling because I'm busy trying to do other things. So I can't tell if someone complaining about audio is if that's a one-off or if everybody can't hear. I don't want to blast you out of your seats. And I know that this court hearing is very difficult to hear. I'm having a hard time with it. And Amy points out, if the money is in escrow, then it's not that Brian is refusing. Look at the smirk on her. Kim saying, for me, it was not trolling. See? Because I ask you, is my audio okay? Okay, so I'm asking you the question. It's can't say it's trolling if I've asked you to tell me, right? Somebody's saying, yeah, Sarah is not used to a full day's work. Kathy, thank you, is saying, for what it's worth, Sarah is going to get an attitude adjustment when she goes to prison. Yep. Or maybe she'll find other like-minded people in there. Who knows? Karen is saying, introduce as much confusion as possible. Yeah. I think when you've got nothing, when you don't have much of a defense, muddying the waters is a tactic. Thanks, Kim. I did figure out how to turn down my mic. And today, I was years old when I learned how to do that. I didn't know how to do that before. Yeah, Captain Katie, or sorry, who is it? Angelica, it looks like somebody turned that mic around. That's good.
All right, thank you all both for your arguments and clarifications. Based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay, all right, thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name, not going to read it, it's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo.
I need,
Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
Okay. As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection, State. Any response?
Any and all exhibits previously listed by the state?
Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted.
Forced to disclose the overt act. Seriously? And by the way, what they're calling the overt act was already known by the people involved behind the scenes, by the prosecution, by the court, because Sarah said it to the doctor. So it's not like the defense had to disclose some great secret.
Our defense that tied in with the self-defense. And so tactically he was able to get us to that posture so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause.
He is re-arguing something he already argued. He wanted a statement of particulars from the prosecution, and this is exactly what he's arguing. The judge said that the state had met their responsibility, so they don't have to lay out their case for the defense. And Owens needed to just move on, but now he's bringing this up again.
Cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission that comes.
Are you serious? Owens, you don't know? At the very least, if she didn't incapacitate him to get him in the suitcase, she zipped him in the suitcase. She forcibly confined him. I think they stated it. The state stated it. She herself stated she hit him with a bat. She zipped him up. He begged for his life. She couldn't breathe. He couldn't breathe. And she knew it. And she left him there to die torturously. While she mocked him and laughed while he's begging for his life. But Owens, you don't see what overt act there was? Really?
Constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So, in an abundance of caution, we've got to list everything that may be relevant. But we don't know yet because we haven't heard. I would like to renew. They've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
The way he's framing this is that the prosecution renewed their motion in limine as if it had been ruled upon and they just renewed it, just brought it up again for no new reason. When the state made that second motion, they had new information and new evidence to back that up. It wasn't simply a second kick at the can. So his game here saying, Dad, it's not fair. I mean, he got to do it, so I want to do it. Well, they're not the same thing. Owens is not bringing up any new argument here. And so far, I haven't heard him cite any case.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do, and we're making every effort to make sure that we understand how this trial is going to go down and how and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day, and right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby, seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain. for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal states that correct. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner.
Oh, really? Because the testimony, her story has been unintentional all along. What Mr. J just did was read us a transcript of that horrific video. So I guess Owen's just going to skim over that part.
5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraph 59 and 60 are also overruled. The only other issue to address then.
So Owens decided to push and play a game. And that gave Mr. J an opportunity to push back. And I think he did so in a phenomenal way.
Is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents. The deputies that went out on the call-outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 states list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days. As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial, Sarah Boone has a right to testify, Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount, and she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this, and the Richardson violations will be in a short recess. Thank you.
Okay, I'm going to fast forward past the break. Oops. Okay. Oops. All right. So I'm going to look at chat. Actually, I am going to switch my cameras around. When they come, this is so I can see the chat better. When they come back online, I will be able to hear it. But if they come back on and it's silent, somebody let me know in the chat. So I just want to see what everybody's saying. Carolina says that shh gets me every single time. Isn't that creepy? Cat Lady thinks sanctions are coming against the defense. You think? I don't know. The sanction might be that they just don't let them bring the stuff in. I don't know. People talking about Sarah's mouth twitch. Sunny Morning Day says Sarah knows she's cooked. She feels badly because she's going down, not because of what she did to Mr. Torres. Yeah, her priority from the very beginning has been herself. Quantum Wannabe says the prosecutor totally rocks. Didn't he do a good job? Wasn't that good? The jury didn't hear that, but they will. Did Owens think he was having a Jimmy Stewart moment because it didn't work? Probably not. Oh, Jane is saying, I'm enjoying this. Everybody running to the bathrooms and a quick smoking break. And she has to be there sitting because she's accused of a murder of a man. Somebody's saying, I'm afraid that Sarah's going to put on a big show and then at the last minute accept the sweetheart deal. I don't think after all this, the state's going to let that happen. Joyce says, Mr. J sounded like he was giving his opening statement. Yeah, he did, didn't he? It was pretty good. Vicinator says she's dangerous and has contributed nothing to society. She's a taker. Yeah, she is a taker. And I think she's not somebody who would, plot to go out and commit serial crimes or something, but she is vengeful and she doesn't care who she hurts. She's going to do what she wants. Remember, she ran down some guy on a bike with her car, and that's not going to come in, but this is who she is. Much Endeavors says the state is taking the gloves off. Linda says this looks like an attempt to hold up the trial again. I don't. Yeah, I don't think so. I noticed some people in the chat earlier during this hearing were saying, "Come on, let's get rolling." But what they were addressing is pretty important. So there are a lot of things that need to get ironed out and made clear and settled before trial. And it's better to do it now than have something happen in front of a jury. So it's better to make sure it's clear now, even if you sound stupid asking. Buttercup saying, "Oh, I thought she hit George on his bike. It wasn't him." I think it was somebody else. I could be wrong. Did they ever rule on Sarah getting snacks? I don't think it was an actual thing where the judge had to rule. It was more like, they'll talk to the jail, because really it's up to the jail. It's not up to the judge. The only time it would be up to the judge is if, for example, Sarah was not getting fed. Oh, I think we're back. Hang on. Yes, and while they're doing this, the jurors...
We're back on the record. Case number 2020, CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
Tony Nicholson for Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow. You are to provide an edited version of those records that you seek to offer into evidence, Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the...
So Owens actually has to do his homework, the teacher said, before 9 a.m. So I guess we'll be here tomorrow at 9 a.m. again.
State's response. Those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Finner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who are the other 2?
Michelle Finner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Castro does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us that juror in seat 25, wearing badge 63, called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any. So stipulated, juror number 25, wearing badge 63, will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the Ora Tennis motion, as to Ms. Boone's request for snacks, the Ora Tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
I am glad that he didn't give her special treatment, because it would have been an issue in the future. Snacks denied. And it's not like she's starving. She gets 2 bagged lunches because of the time that she shows up. So she's not being denied food and hydration. And in those bagged lunches, apparently there are cookies. I don't get cookies. Somebody's saying they haven't seen this go on before jury selection before, or in the middle of jury selection. I think there's a lot of trying to cram things in, because this judge was making sure that this wasn't delayed yet again. She looks haggard and it's only lunchtime. I think this is difficult. I don't think she's ever had to sit and attend for this long. Carolina thinks that Sarah will reoffend. Good chance. Somebody's saying Sarah wants her comfort food. So she's sitting at the table, got to be unconstrained, got to yuck it up a little bit, and now reality. Right? But she'll go in the back, they'll feed her, she'll be fine. Well, actually, they won't. They refer to the basement, so I guess they're holding us in the basement. Joyce is saying Sarah's probably better dressed than she has ever been. Yeah, probably. Except maybe at her wedding. There she goes. Okay. Let me change screens around so I can see chat better. So I'm going to address some comments and questions before I end the stream and make sure that I didn't miss something important here. Buttercup is in agreement that she can't handle full days of anything. Yeah. Oh, Angelica saying the packet of extra buttons was still on the inside of her suit jacket. Yeah, I don't think they'll get away with returning it. I don't think so. Captain Katie, yes, defense would pay for any costs relating to expedited transcripts because they've just come up with these. That whole thing was, interesting because, again, at the last minute, they're coming up with witnesses. And then Owens gets up and while he's talking, he's kind of patting Sarah on the shoulder. Whoops. Oh, Kathy's talking about the price tag on the shirt. Anyway, Owens is patting her on the shoulder, almost like fatherly, like reassuring her and telling the judge, well, these are witnesses Sarah thinks that we should call, but we might not call them because it's actually up to me. So, but if they do, the state is going to want them deposed before going on the stand. And why should the state pay for that? So I thought that was good. Jay Soul is saying, do you think Sarah had any friends before this happened? Probably. Soul Rack is saying Sarah is toast. Maybe. But they're going to put on a vigorous defense, as they should. As they should. Sometimes things look really bad when you see them on the news, and it turns out that there are other factors at play. Late bloomer, just the transcript of the suitcase torture brings me to tears. Poor George, my heart goes out to his family. Yeah. Yeah. Very solemn section there. Impactful. The defense has how many people working for Sarah? 5, 7? This is crazy. Well, if she could get a whole team, more power to her. Good. Every defendant should get lots of opportunity to defend themselves, because then when they're convicted and they are given a tough sentence, the rest of us can be assured that the right thing was done. There are people who go to jail and are wrongfully convicted. So CJ saying that transcript is gut-wrenching. Yeah. That I saw the video too, as did so many others. And yeah, it does. You can't forget that. Sand Dollar, yes, she hit him with a bat and she actually admitted it. Mad Mystic is saying no one can truly envision what he suffered through in the end. Yeah. And his mother has to live knowing that her baby died like that alone. Mad Mystic, you're going to make me cry. What mother can't relate to that? How that mom feels, regardless of what you think of Mr. Torres, that's still her baby. And that video of that suitcase, of that torture in his last moments, got plastered everywhere. And the suffering of the family is why I did not play that on my channel. So, Carolina, although everyone is looking forward to opening statements, Judge Kranek has to address all of the poppycock that the defense is ditching out. Yeah, and some of it actually isn't poppycock. I think it's okay for both sides. I think it's a good thing to make sure that they understand how things are going to be going forward. Because we don't want a mistrial and we don't want a big, different kind of hearing in the middle of the whole thing when the jury's tired and then the jury has to wait for that. Just get it sorted out now. I think that's good. Carla is asking, if Sarah's convicted, will there be any enhancements added? Since she admitted using a weapon such as the baseball bat or suitcase, I suspect that the state will make arguments for enhancements, but I can't tell you what's going to happen. Buttercup says, why aren't her legs shackled? Because Owen successfully argued for her to be unshackled. Yeah, Carrie B says, yeah, Sarah herself told the bat story to the therapist at the jail, knowing that this would be used in court. Unhyphenated is saying, as a mom, I would think that I would want it all to be played everywhere so the world knows what that heifer did to my child. I could see that. I could, people think differently. I can certainly see that. Yeah. Kathy, I've had a charm made for my bracelet that says justice for George because he mattered and I'm a big fan of justice. Wow. Yeah. Every single victim matters. And there is no such thing as a victim who is pure as the driven snow, unless we're talking about a baby. Every one of them matters. Yep. Miriam says, Sarah's twitching mouth reminded me of Shanda Vander Ark. She too was a torturous murderer. Oh, for some reason she triggered the crap out of me. Cat and Katie thinks she's got a stun cuff on. She does not. That was the original agreement, but Owens got her completely unshackled. Chrissy says, I feel bad for Brian. Yes, Brian probably moved to get away from all of this, and Owens just doxed him. I was thinking that while Owens pretty much gave away his address. Not his address, but at least the area where he is. Linda's asking if the neighbor who heard the thud down the stairs is a witness. The answer is yes. He's on the witness list. And what will that mean? Well, I expect it means what you think it means, right? Carrie B, the worst thing you can do to a narcissist is say what they did out loud. Sarah's entire identity is splitting right now. Her head may explode. Yeah, there is something called like a narcissistic collapse or narcissistic mortification where the narcissist can't escape facing that reality. It creates intense shame. And I think she has a narrative in her head, a fantasy. Now, when I say fantasy, I'm not talking about a break with reality here. She knows. She's in touch with reality, but she has the fantasy in her head that she needs to maintain that she's not a murderer, and she needs for everybody else to believe in that. Alex is saying, yeah, don't you just ache for poor Lucas? Yes. So Nikki's asking, does the defense still have their voir dire today? Yes. So while they were continuing to argue and everything, the jury is waiting. The jury was told to be there. The potential jury, the pool, was told to be there at 10 a.m. So those poor people were sitting around waiting. And so now Owens, or the defense, whoever's going to be asking questions, I think it might be Henderson, gets to ask questions of the jury, and then both sides will go through and do their challenges for cause. But in any case, we are going to be here tomorrow morning at 9 a.m. to address the Richardson hearing. AKA the cat lady says, do you guys believe that Owens really doesn't know what Sarah did wrong? Looks like, cat lady, you are asking the chat that question, so I will let people answer. Carrie, her false self is being destroyed. Yep. Yeah. Michelle is responding to Addie in the chat saying, I think Owens is covering all his bases so he doesn't have to deal with her ever again. Cram is saying, if you turn up trial, gotta turn down your mic. Yeah, tech is not my thing. I am trying the best I can. So I prefer to kind of figure it out right at the beginning of the live so that, so I'm not trying to fiddle with it halfway through. So it's helpful if you guys tell me at the very beginning. Amy says Owens is stuck with her for life. No, he's not. Okay, guys, I will see you guys tomorrow morning. I'll come on again at about 9 a.m. See what's going on. We won't be able to hear you. Okay. So I will see you tomorrow morning at 9 a.m. Thank you so much for joining me. This is so much better with you guys. It's better to watch it with you guys. And I feel like I'm not alone screaming at this screen. Trust your gut. I'll see you on the other side.